Quick edition of Lumberjack Logic Live. I'm your host, Neil Johnson. Always excited to be with you and to share the news with you. Just doing this on my iPhone, doing a little old school here. Just trying to get this news out quick. But a huge win, folks, in the appeals court. Slapped down a Joe Biden judges. Okay, so this was a judge appointed by Biden who had put a block on Trump's executive order aimed at eliminating DEI. And as we get into this, you're going to see just how glorious this decision is. And I love some of the writing in this decision. So I'm going to read to you from a couple articles, and then we're going to right into the decision itself. I also have another big court issue in play and another thing that went wrong in Minnesota that you do need to hear about. So do me a favor, please smash that like. Do chat in with where you're from. And as people are joining, I see Shawnee, Oklahoma on the screen. Scoop, I see out there. George, Northern Grace, all y'all, thank you so much for joining me today. Again, please smash that like if you would to help get this news out. But also, while we're waiting for a few more to join, go to mypillow.com. Get yourself some Rev 7 energy drinks and some pillows and sheets. Giza sheets in stock. All right. mypillow.com/lumberjack or 1-800-568-2865. Free shipping on mattresses and mattress toppers right now. All right. Here we go. So we've got this huge win. The appeals court slaps down the Biden judge's block on Trump's executive orders aimed at eliminating DEI. Now, this is big for so many reasons, people, because this was discrimination at the highest level on awards of federal government contracts. And wait till you hear how the court discusses this. It's absolutely beautiful. I didn't even know there was a Cleveland in Tennessee. I think Cleveland, I think Ohio. And you have to understand, too, folks, that this was in hostile territory. The injunction was vacated, okay? So there was an injunction issued against this, the executive order. It can that is basically gone. But it was a unanimous opinion on a 3-judge panel. There was Chief Judge Diaz, who was appointed by Obama, Judges Harris, Obama, and Rushing, Trump. This is a huge civil rights win for the Department of Justice, okay? So let us go into, I'm going to read just briefly here from the New York Post to give you a little bit of background on this. A federal appeals court ruled Friday that President Trump's executive orders on DEI initiatives among government agencies and contractors can go into effect. A 3-judge panel, which I told you about, okay? But all concurred that Trump may determine his policy, listen to this, may determine his policy priorities and instruct his agents to make funding decisions based upon them. President Trump has decided that equity isn't a priority in his administration and so has directed his subordinates to terminate funding that supports equity-related projects to the maximum extent allowed by law, wrote Diaz, appointed to the bench by President Barack Obama. Whether that's sound policy or not, folks, isn't our call, this the Obama judge said. We ask only whether the policy is unconstitutionally vague for funding recipients. Abelson had initially granted a nationwide injunction, which was batted down in March of 2025 by the same judges, and later a preliminary injunction, which of course is now vacated. Baltimore's mayor and the city council, the American Association of University Professors, the National Association of Diversity Offers in Higher Education. Listen to this, folks. They have a National Association of Diversity Officers in Higher Education. These people were the types of people that sued the Trump administration, claiming the order violated provisions of the Constitution's First and Fifth Amendments. You cannot make this up. They are saying that this violated the Constitution's First and Fifth Amendment. In other words, they're saying that your government funding, your tax dollars, not going to racially based, quota-driven crap is somehow violating the First and Fifth Amendment. And no, I'm not kidding you. Oh, this was all signed on day one. This was one of his day one executive orders, okay? Give you just a little reading from it. The Biden administration forced illegal and immoral discrimination programs going by the name Diversity, Equity, and Inclusion into virtually all aspects of the federal government in areas ranging from airline safety to the military. We saw that with airline safety, and then the airline wasn't safe anymore, okay? This was a concerted effort stemming from President Biden's first day in office when he issued Executive Order 13985, advancing racial equity and support for underserved communities through the federal government, Trump said. Okay? Now here's where it gets good. I'm going to go directly to the decision. Okay? It still blows my mind that there's a National Association of Diversity Offers in Higher Education. There shouldn't be any diversity officers, and the fact that there's enough of them to form an association is really troubling, folks. Okay? And American Association of University Professors and the mayor and city council of Baltimore, Maryland, of course, versus Donald Trump, and then every single department Donald Trump has as the defendants. Okay? And then American Center for Law and Justice, they talk about the amici, whatever, briefs. But here we go. This is Diaz, the chief judge, writing. Reading right from the decision here, folks. Okay? Right from the decision. Listen to this. In the first days of his second term, President Donald J. Trump issued 2 executive orders that directed executive agencies to end diversity, equity, and inclusion programs within federal grant and contract processes. Again, I think about the lunacy of this. You are supposed to award grant money, and the grant processes need to favor people based on these stupid DEI initiatives. Okay, that would seem like discrimination to me. Just saying. So it goes on about the executive order and then who sued. But the district court entered a preliminary injunction, but we stayed it pending appeal. We now vacate the district court's injunction and remand. Consistent with his campaign promises, President Trump acted swiftly to eliminate DEI programming and funding in the federal government and private sectors. 2 executive orders he issued sought to do just that. The first was entitled Ending Radical and Wasteful Government DEI Programs and Preferencing. Contains what Trump calls the termination provision. That provision directs all agencies, departments, and commissions to terminate to the maximum extent allowed by law all DEI, DEIA, and environmental justice offices and positions, including but not limited to chief diversity officer positions, all equity action plans, equity actions initiatives or programs, equity-related grants and contracts, and all DEI or DEIA performance requirements for employees, contractors, or grantees. Okay, the second was entitled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. Don't you love it, folks, when we live in a meritocracy where the best ideas rise to the top, no matter the color of your skin, but actually based upon the content or your character or just the flippin' work that you do, right? Don't you just want it to go back to a time where you know that the best airline safety person is hired, not based upon, their skin color, for Pete's sakes, okay? Contains what plaintiffs call the certification provision and the enforcement threat provision, okay? So this is what the plaintiffs were claiming. The certification provision instructs that the head of each agency to include in every contract or grant award a term requiring the contractual counterparty or grant recipient to agree that its compliance in all aspects with all applicable federal anti-discrimination law is material to the government's payment decisions for purposes of Section 3729B4 of Title 31 United States Code. Do you guys catch this? So what they are complaining about in the lawsuit, what this was all about, was this certification provision is what they were so upset about. And that term simply required that the contractual counterparty, in other words, who the government had contracted with, or grant recipient, they would have to agree to comply in all respects with applicable federal anti-discrimination law. In other words, the people who are telling you that they're anti-discrimination were opposed to abiding by anti-discrimination laws. Do you guys get this? I mean, are you following with me on this order? Just say yes or no in the chat. This is absolute lunacy to me that this was even a court case, that our courts wasted their time on this, and that some idiot judge actually granted an injunction in the first place. You have got to be kidding me. And B, a term requiring such counterparty or recipient to certify that it does not operate any programs promoting DEI that violate any applicable federal anti-discrimination laws. Okay? The enforcement threat provision tasks the head of all agencies, with the assistance of the Attorney General, to prepare a report within 120 days of the order, identifying a plan of specific steps or measures to deter DEI programs or principles, okay, that constitute illegal discrimination preferences. Again, I can't believe here's the left telling us that we're the ones who are discriminating, and they are actually fighting anti-discrimination enforcement. Freaking mind-blowing. Implementation of the order soon followed. Okay, so all the departments went through this. The Federal Communications cited the orders in announcing that it was investigating Comcast, NBC Universal because the media conglomerate may have been promoting invidious forms of DEI. The commission also noticed that it had already taken action to end its own promotion of DEI. Department of Justice memorandum, so on. As relevant here, the Department of Health and Human Services directed Baltimore. Okay, so remember, that was one of the parties to the lawsuit, the mayor of Baltimore, a Centers for Disease Control and Prevention grant recipient, to immediately terminate all activities promoting DEI that are supported with funds from Baltimore's award, given the orders. Seems to make sense, folks. If you're going to take these federal government dollars, which shouldn't even be given in the first place, folks, the grant dollars, that's the whole other issue. Okay, so oftentimes we're focused on these ancillary issues about how this shouldn't be based on DEI. The reality is they shouldn't be getting the money in the first place. Are you kidding me? Okay? The National Science Foundation refused to approve travel requests for a member of the American Association of University Professors, given uncertainty about whether the member's project regarding gender disparities and diversity in the sciences aligned with the administration's executive orders. Heaven forbid, okay? And a university issued a stop order on another member's National Academy of Sciences funded project, which focused on equitable service access, after the academy terminated a different project at the same university, citing the orders. Okay, it goes on. All the harms against, all these agencies that had to automatically stop being racially discriminatory. And so they sued. They're freaking amazing. Plaintiffs sued seeking preliminary injunctive relief. They argued that the termination and enforcement threat provision facially violated the Fifth Amendment, and that the certification and enforcement threat provision facially violated the First Amendment. The district court found the provisions likely unconstitutional, granted the injunction. Defendants then appealed and moved for a stay of the preliminary injunction, which we granted soon after the plaintiffs moved to vacate the injunction so they could amend their complaint, but the district court denied the motion because it remained of the view the plaintiffs have a strong likelihood of success on the merits of their constitutional claims. Okay, but they didn't. We review a district court's grant or denial of a preliminary injunction for abuse of discretion. So then it cites a bunch of case law. I'm going to skip the case law for you. I don't want to bore you guys. But first, plaintiffs must show that we have jurisdiction to hear their case. In other words, that they have Article 3 standing to bring their claims, and that the claims are ripe. The court started their analysis there, so listen to this. The district court concluded that plaintiffs had standing for each of their claims. We review that determination de novo, and then they do the, case law, and disagree as to the enforcement threat position. Article 3 standing requirement centers on whether the party invoking jurisdiction had the requisite stake in the outcome when the suit was filed. This is where it gets so good, folks. Because remember, guys, what did we hear on all these election lawsuits? Okay, what was the words we always heard? You don't have fill in the blank. You don't have, What was the word? What did we not hear? Why were we not able to hear? I still don't understand. Like, if Donald Trump wasn't able to bring a suit about the election he was involved in, I don't know exactly standing. So here we go. Standing also tends to assure that the legal questions presented to the court will be resolved not in the rarefied atmosphere of debating society, but in a concrete factual context conducive to a realistic appreciation of consequences of judicial action. To establish Article 3 standing, the plaintiff, whether an organization or an individual, must show that they suffered an injury, in fact, that is concrete, particularized, and actual or imminent. So listen, they don't have standing, folks. This is what they're ruling. that they suffered an injury. They have to have suffered an injury, in fact, that is concrete, particularized, and actual or imminent, that the injury was likely caused by the defendant, and that the injury would likely be redressed by judicial relief. Okay? They say we may somewhat relax the injury in fact requirement. The First Amendment case is given that the risk of punishment could chill speech. Okay? We hold the plaintiffs lack standing to challenge the enforcement threat provision. To begin, as defendants explained at oral argument, agency heads and the Attorney General prepared the required report and submitted it to the president in June. So it's unclear how an injunction could address any plausible harm stemming from a report issued months ago. Indeed, the administration's preparation of the report may have mooted plaintiffs' challenge to the enforcement threat provision. But because we evaluate plaintiffs' standing as of the time they filed their complaint, before the report was issued, we'll assume that we could redress such harm. Even so, plaintiffs have not sufficiently alleged an injury in fact. They claim, listen to this, they claim that the fear of retribution by defendants and that they'll be forced to restrict their speech and conduct in support of diversity, equity, and inclusion or face penalties. But these allegations overstate the enforcement threats provision text. First, everything, listen to this, folks, everything about the provision is intragovernmental, okay? And the president has directed the Attorney General to spearhead a report that will further inform or advise him. Though the report might graze the private sector, the provision itself focuses on the internal government agency processes and programmings and reporting to the president from his subordinates. None of the plaintiffs, of course, are an agency within the executive branch of government. Again, remember who the plaintiffs were. Not a single one of them were in the executive branch of government. We're talking about a National Association of DEI officers, a National Association of University presidents, and then a mayor from Boston, okay? Second, injury rests on a highly attenuated chain of possibilities that does not satisfy the requirement that threatened injury must be certainly impending, okay? Such multi-tiered speculation is inconsistent with Article 3 standing. That's right. It's all speculation. So we lack jurisdiction to hear plaintiffs' constitutional claims related to the enforcement threat provision. The termination and certification provisions, jurisdictional allegations, are altogether different. For those provisions, plaintiffs plausibly allege that they will lose. This is so great. Listen, this is my favorite part. This is my favorite part of this all. Okay, I can't get through this. The termination and certification provisions, jurisdiction allegations are altogether different. For those provisions, plaintiffs plausibly allege that they will lose access to money, a classic pocketbook injury sufficient to give them standing. For the termination provision, plaintiffs allege that they or their members had grants canceled on account of the executive orders that would have funded equity-related work and travel. You know how they're all lining up for government money, right? Government grants. They all want their free money, and then they spend a bunch of it on their travel expenses. They fly around the world. They stay in nice hotels. They eat 5-star meals, and they bill it all back to us, the taxpayer. Frickin' pisses me off. The Department of Health and Human Services likewise demanded that Baltimore immediately terminate all activities promoting DEI and supported by its federal grant money. Plaintiffs also identified other awards at risk of termination due to the anti-equity termination provision. Okay? It just goes on. The injuries, it's all speculative. And do you know what really blows my mind? Again, I cannot believe that they ever got a temporary injunction on this. That judge had to be so whacked out of their mind. I'm so glad this is done through the appeals process because they can't take it anywhere else, folks, because they would lose at the Supreme Court because this is the stupidest case I've ever seen in my life. How can you say that you are going to be harmed when you're simply asked to provide proof that you're not acting discriminatorily? I thought that was the whole point of some of our laws. And yet this is the crap we get. And then they're taking your money. If this doesn't piss you off, I don't know what will. This is like Leering Centers in Minnesota, folks. This thing just goes on and on and on. But the bottom line, folks, all that said, it is true government regulations that require or forbid some action by the plaintiff almost invariably satisfy both the injury in fact and causation requirements. So in those cases, standing is usually easy to